Hi, this is Peggy Clary of Clary Law Office again, one of our estate planning attorneys. And tonight's topic on our video shoot, which we do each day, really stems from a comment my mother made to me after watching some of our videos. So she was very kind and logged onto the website and began to watch, and then said to me, "You know, you should use a filter. You just look so haggard and tired." So I apologize to all of you for looking haggard and tired. But it made me laugh because sometimes in our own families, when we're making a will, our parents or maybe a relationship with a sibling, you may come as a client with a lot of concerns about having that person inherit under your will. So a huge common question I get is, how can I exclude this person and make sure they don't challenge the will? And it's really a multi-tiered answer, but hopefully these 3 tips will help you have your will reflect your true wishes and make sure that if you want to exclude someone, they can't come back and really raise an unnecessary challenge. So the first way is you make a will. And when you make a will, Florida law is very clear that the person you name as your beneficiary is your heir, and you are able to name who the heir is going to be, and for many people it's good to name a backup just in case they predecease you. So naming the heir is the first good tip. Identifying them fully by their relation, by their name, but that way there's no confusion or mistake about who you want to be the heir. Second way that you can avoid maybe an unnecessary challenge is if you specifically want to exclude someone, you can use some language that says it's not for any lack of love or affection. I've made no provision for the following person. We don't use anymore, I leave them $1 so they don't challenge the will. That's really not supported in the law, but we do make an effort to specifically exclude the person who you don't want to inherit. The third way that you can really avoid an unnecessary challenge in your will is to think about the circumstances in the execution of that document. So to avoid situations where someone could make a claim that you were either unduly influenced or not in your right mind when you did it. Maybe you didn't have competency to do that. And a common problem I see is mom's driven to the lawyer by daughter number 1. Daughter number 1 sits in the estate planning conference. Daughter number 1 is there at the signing. So there's really an argument that could be made that perhaps daughter number 1 influenced mom to do a plan which she really shouldn't have done. So a good thing to do is, if your adult parent wants to make a will, certainly there's no problem with you driving them to an attorney's office, but to be recognizing, to be cognizant that that attorney-client relationship, it might be better to sit outside and not participate in the conference, but making good decisions in how you execute the document and the circumstance around it is a very effective means to avoid having your will challenged. Of course, the simple answer to all of this is, if you don't want someone to be a beneficiary under your will, then make a will, and make a will that enumerates or lists who your beneficiary is in the right circumstances, and thinking about that planning ahead is always important. Now, I want to reassure all of you that I am not excluding my mother from my estate planning, that she is truly a kind woman, and that I'm sure her comment was only meant, as most mothers, with great love and support of trying to be the best you can as a child. But thanks again for watching. I hope your life is marked by dignity, civility, and respect. And if we can help you at Clary Law Offices plan for a will which correctly reflects your wishes, avoids any unnecessary challenge, then we welcome to help you. And thanks again for your time.